Hello there, you're watching SABC News Channel and this is a full view. I'm Tshepiso Makwetla. In the headlines tonight, the Springboks conclude the Gauteng leg of their World Cup victory tour. A Concord ruling sees former crime intelligence boss Richard Mdluli acquitted of intimidation. Jacob Zuma has to apologize to Derek Kanekon for calling him an enemy agent. Question of the day, the Springboks have done their bit for the national psyche. We're asking you, how do we keep the momentum going? Send us your comments to #FullView. You can also find us on +2766 479 8056 for voice notes or video calls. View any of our interviews or features on sabcnews.com. We're also available on Facebook and Twitter. Former crime intelligence boss Richard Mdluli is off the hook on 4 convictions of intimidation. This follows a recent Constitutional Court ruling that sections of the Intimidation Act were unconstitutional. But his woes are far from over. Mdluli and his co-accused Mthembeni Mthunzi will be sentenced next year on the remaining charges of kidnapping and assaulting Oupa Ramogibe in 1999. Ramogibe was shot dead in the same year.
In a dramatic turn of events, the Constitutional Court ruling put a spanner in the works of what was meant to be D-Day for Mdluli and his co-accused.
The essence of your judgment, with respect, my Lord, remains in place. There is the small bit that has to be cut off and has to be severed. We respectfully submit. The sooner, the better.
In a landmark ruling on the 22nd of October, the Constitutional Court ruled that sections of the Intimidation Act are unconstitutional as they limit freedom of expression.
The Constitution supersedes even the common law. Common law or not, statute or not, that's it.
The court forced to concede.
Pursuant to the Constitutional Court judgment of Moyo, is that accused number 2 is acquitted on charges. Is it intimidation? Is 1, 2, 3, and 4. Okay, 1, 2, 3, and 4. All right, and then we shall proceed with the others.
Good news from Mdluli.
I'm pleased about the outcome of the judge currently. It is still too early to talk about the whole matter because we still have to deal with the other 4 charges which are left. And as soon as that has been done, then one will be in a better position to comment further about this whole matter.
But justice delayed for Ramogibe's family, who still do not know who killed him.
Today, I was really hoping this case would end. It's been long. I am tired. This is so hurtful for me.
While it's still a long road before this matter reaches finality, pre-sentencing arguments have been postponed to the 3rd and 4th of February next year. It's expected a close family member of Oupa Ramogibe will take the stand. Griselda Lewis, SABC News at the High Court in Johannesburg.
So to talk about this, practicing advocate Dr. James Grant joins us now on the line. A very good evening to you and thank you so much for speaking to us, Dr. Grant. Now, at issue is a judgment by the Constitutional Court that found that sections of the Intimidation Act were unconstitutional, finding that it limited the right of freedom of expression. Now, what exactly does this mean?
Well, what the court there found is that a particular subsection of the Intimidation Act did not, in fact, constitute incitement to imminent violence, which is what the line which is drawn in respect of hate speech in our Constitution. And therefore, so for instance, the particular subsection in the Incitement Act, which says that one may not in any manner threaten to kill, assault, injure, or cause damage to a person, that's unconstitutional because it doesn't cross that line of incitement to imminent violence. And just to give you some perspective on it, one could be muttering to oneself that you are going to kill a particular person, and on the act as it stands, you would be guilty. Now, any sensible person would say that goes far too far, and so it was inevitable that the Constitutional Court would find this to be unconstitutional.
So Justice Leone Taron finding that Section 1, Subsection 2 of the Act created a reverse onus. So please explain this to us in layman's terms.
That's a tall order, but I'm going to try. It's a very technical argument. What it really does is it places, and I'm going to use the technical term, a burden on an accused person to raise more than a reasonable possibility that they might not be guilty. Now, the word that I've used is reasonable possibility, and that an accused needs to raise more than that in order to get off. Whereas on the ordinary standard in our criminal law, all that an accused needs to do is to raise a reasonable doubt, which, when one understands it properly, equals a reasonable doubt. So the section was asking of an accused person to raise more than a reasonable doubt, and therefore it had to be found to be in conflict with the generally understood presumption of innocence.
Another thing I'm going to ask you to unpack is the state said that the ruling has a profound effect on the 4 charges of intimidation that Mdluli was found guilty of, and it argued that such a ruling has drawn a line through those convictions. What does that mean?
Well, I think those convictions couldn't stand given the fact that the Constitutional Court in the Moyo decision in October was very clear to make the effect of its ruling then retrospective and effective on cases that are currently still before our court. That's unusual because the ordinary position is that when the Constitutional Court gives a decision, it is not of retrospective effect. But when you read the Moyo judgment, the Constitutional Court was at pains to say that this judgment of ours is retrospective, which means any case that's still before the court, it's going to apply to, and therefore it had application here.
And just a summary of that Moyo case, it says that Section 1, Subsection 2, and 1, Subsection 2 also presumes that the accused's actions or utterances are without lawful reason if such a reason was not advanced prior to close of prosecution case. It's all very technical, but I'm going to ask you to please break that down for us as well.
Sure, that takes us back. So we're really talking about Section 1, Subsection 2, once again, which is the section which has been found to create the so-called reverse burden. And the reverse burden is where an accused person is being asked to create more than a reasonable possibility, more than a reasonable doubt that they are innocent. And the moment that happens, our courts have always found that that section cannot exist in our law and must be held to violate the Constitution and the presumption of innocence.
Judge Ratam Khwatleng in this case pointed out that the constitutionality of the laws has changed, and that doesn't mean that the law never existed. Explain this to us.
Well, I suppose it just makes sense of the fact that at one point in time it was illegal, or it was quite right to have found, before the Constitutional Court in fact struck these sections down, that a court operating properly could have well convicted a person on that. But the Constitutional Court has now spoken, and whereas usually once they've spoken it only has prospective effect going forward, it has spoken and made it retrospective, which is unusual. And it's about making sense of how in this unusual case, we now have to take account of what the Constitutional Court has said.
All right, thank you very much for speaking to us there. Dr. James Grant, he is a practicing attorney. Now, the former head of government communications, Wanele